Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today may be the day I earn your subscription. For today's story, we are talking about perhaps the last chapter in the Derek Chauvin story. Derek Chauvin, as I'm sure many of you will remember, was a police officer in Minneapolis, Minnesota, who was convicted by a Minneapolis jury of murder in the second degree, among other charges. He was additionally charged with federal crimes, and those federal crimes came to a conclusion today by agreement. A plea deal has been entered as to those federal crimes. So in addition to his state level convictions, he now has federal level convictions relating to the same fundamental incident. Of course, they're different legal charges, and they're also from separate sovereigns. So we're going to read this, and we're going to discuss how this might impact Derek Chauvin, and also, of course, might impact the other people that are involved in the case, because it wasn't just Derek Chauvin that was charged. The three other officers are still awaiting their trial in state law for their role in assisting or being accomplices to all this, which doesn't really work for me. But we'll see how this might impact all those things. So let's go ahead and get started with this. So we're just going to read this plea deal, which was agreed upon and entered into the record today in the United States District Court in Minnesota. The United States of America and Derek Michael Chauvin, the defendant, agreed to resolve this case on terms and conditions that follow. This plea agreement binds only the defendant, the United States Attorney's Office for the District of Minnesota, and the Civil Rights Division of the United States Department of Justice. This agreement does not bind any other United States Attorney's Office or any other federal or state agency. I don't think he has any other exposure, so it doesn't really matter in this case. The charges. The defendant agrees to plead guilty to count one of the indictment and count one of the information, each of which charges the defendant with deprivation of rights in violation of 18 U.S.C. 242. All right, so let me tell you a little bit about what's going on. So there's actually two incidences that are in play in these federal charges. There's a prior incident involving a juvenile that Chauvin pulled over and, mishandled. And there's also the death of George Floyd. So he's being charged with deprivation of rights for both of those cases. So the mishandling of the juvenile, the mishandling of Chauvin. And both are under 18 U.S.C. 242, which basically says in so many words, that's a violation of federal law when you violate someone's rights based on color, among other protected classes. So when it is a protected class, and that's the basis of it, what you might call a hate crime, then that is a federal hook. So he's pleading guilty to both of those. Now, these are both felonies. Now, thanks to the Constitution of our great country, felonies that come from the U.S. government must be charged by indictment. But, of course, that can be waived, like anything else. And so Chauvin agreed to waive the indictment. So, notwithstanding the constitutional provisions, which require indictment, he agreed to, in this case, only be charged by information. So just the prosecutor just saying stuff, as opposed to the prosecutor going to the grand jury. It's not like the grand jury wasn't going to say it too. Of course they were. So it's like, yeah, skip a step. So just by way of, a little bit of legal background, legal knowledge, that's what happened. One was by indictment, there was a grand jury, and one was by information because the defendant agreed to, waive the requirement for grand jury. So, okay. The defendant fully understands the nature and elements of the charges or crimes which he's been charged. The defendant's expectation is that, as a result of entering this agreement, he will serve a sentence of imprisonment in federal custody. So this suggests, although it does not flatly state, that he might serve all the time in federal custody as opposed to state custody. So that might be part of the deal here. It's not stated because obviously the federal government can only speak for itself. But there might have been an arrangement behind the scenes that he would serve all the time in federal custody. Now, in case you're wondering, in terms of just straight up law, who gets priority, the answer is whoever got to him first. So the state of Minneapolis has to agree. The federal charges don't supersede the state charges in that way, and the federal sentence don't supersede the state sentence in that way. So if Minnesota wants to keep him, they have every right to keep him. So it would only be in federal custody by agreement with the state of Minnesota, which they might be very willing to do for a whole number of reasons. But, just a little FYI as to law, who wins, whoever got to him first. At the time of sentencing, the United States agrees to move to dismiss, as does defendant, additional counts. So additional things have been waived. The defendant is pleading guilty because he is in fact guilty of count 1 of the indictment and count 1 of the information. This has to be agreed by both parties. So Derek Chauvin says this is true, right? He's pleading guilty because he is in fact guilty. In pleading guilty, defendant admits to the following facts that are true, and from those facts establishes his guilt beyond reasonable doubt and constitute relevant conduct pursuant to the United States sentencing guidelines. Defendant acknowledges the following facts are only a partial summary of the government's evidence. So he admits to all these things, whatever else the government might have. On or about May the 25th of 2020, in the state and district of Minnesota, when they say district here, they mean federal district of Minnesota, because there could be more than one district. Some states have more than one district, so that's what they mean. The defendant, while acting under the color of law, and that means as a police officer, and while aided and abetted by other officers, debatable, willfully deprived George Floyd of his constitutional rights, specifically the right to be free from unreasonable seizure, which includes the right to be free from use of unreasonable force by a police officer. The defendant held his left knee across Floyd's neck, back, and shoulders, and his right knee on Mr. Floyd's back and arm. As Mr. Floyd laid on the ground, handcuffed and unresisting, the defendant kept his knees on Floyd's neck and body, even after Mr. Floyd became unresponsive. This offense resulted in bodily injury to and the death of George Floyd. Specifically, defendant admits that on May 25th, 2020, he was on duty and acting under color of law as a patrol officer for the Minniapolis Police Department in the city of Minneapolis, District of Minnesota. Again, when we say District of Minnesota, we mean federal court districts. Through his experience as a MPD police officer, the defendant was familiar with policies and training regarding the authorized use of force, including the requirement that an officer use force only in proportion to a subject's resistance, and the requirement that an officer stop using force when a subject is not resisting. This is true. Defendant was also familiar with policy regarding requiring officers to intervene, regardless of rank or seniority, if they observe other officers using inappropriate force. Defendant was also aware of policy and training that once an arrestee is in custody, which he was at the very point that he was in custody that whole time, the arrestee is the officer's responsibility to protect, and accordingly, officers are required to provide emergency aid to an arrestee who needs it, including CPR and other basic first aid, even while awaiting EMS. Okay, so there's a lot of things there that we need to talk about. As we have talked about on this channel, the police in general have no duty to protect any particular person in general. This holding has been confirmed by cases such as Castle Rock versus Gonzalez, or DeShawnee versus Winnebago, or Warren versus DC. The police, in general, have no duty to protect any particular individual. So if the police just ignore you, you can't sue them. That's not a crime for them. It might be a disciplinary violation for them, so they might be able to get fired by their police department, but no remedy for you. So, but there is a notable exception to this. There's a notable exception to this when the government has you in their custody, because at that point you can no longer care for yourself. You're inside their custody. You're inside their control. So if you are in the custody of the government, whether that's by a jailer or by a police officer, now the police officer does have affirmative duties to you. They have put you under their dominion, under their control. And you no longer have the ability to care for yourself. Therefore, the police have an affirmative duty to you, which means that, and he was undoubtedly in his custody the entire time. I mean, he was in his custody and control and in his dominion the entire time. So that means that, yes, he has an affirmative duty to Floyd, which includes an affirmative duty to provide CPR and other first aid even while awaiting EMS. He has a duty. He has a duty. So yeah, he's required to do those things. So there's that. And when you fail to perform an affirmative duty, that's illegal. So it's illegal to do things you're not allowed to do. It's also illegal to not do things you're required by law to do. So, yeah. Finally, the defendant was trained that if an arrestee is in the prone position, the position may make it more difficult to breathe, and thus officers should move the arrestee to a side, recovery, or seated position. Excuse me. The defendant further admits that he did not, at any time on or before May the 25th, 2020, threaten or force officers Tao Theo, J. Alexander Kung, or Thomas Lane to disregard or fail to comply. So that, it wasn't that I ordered them, so that goes to potentially their liability. On the evening of May the 25th, 2020, the defendant and his partner, Officer Tao, responded to a dispatch call regarding a counterfeit bill. Officer Kung and Lane were already on scene. After an attempt to seat Floyd in a squad car, the defendant and officers Kung and Lane maneuvered Floyd, who was handcuffed and requesting to be placed on the ground, out of the vehicle and face down on the street. So he is in handcuffs at this point, which is important to go to his ability to potentially resist or otherwise be a danger. That isn't to say he's a non-danger. It just goes to lessen the danger substantially. Mr. Floyd remained restrained, prone, and handcuffed on the ground for approximately 10 minutes. During this entire period, the defendant had his left knee on Mr. Floyd's neck, back, and shoulder area, and his right knee on Mr. Floyd's left arm and upper back. During the entire time, officers Kung and Lane aided the defendant in restraining Mr. Floyd, that they were touching Mr. Floyd in some way. During much of this time, Officer Kung and Lee physically assisted the defendant in restraining Mr. Floyd. After the initial restraint, Mr. Floyd stopped restraining officers. So there was some resistance before the restraint. So there was some resistance before this, but if resistance stops, the use of force has to stop, because someone can surrender to the police after, being resistant. So what they're saying is after that initial restraint, he stopped resisting. So any resistance had stopped at that point, whatever happened before. Defendant admits that no later than the time the officers decided not to apply the hobble to Mr. Floyd, defendant continued use of force became objectively unreasonable and excessive based on a totality of circumstances. So there was discussion about whether they should move him into this recovery position. You heard it from the other officers on tape. It's like, should we move him? Should we move him? And that's kind of what screws him here. So, when did it become objectively unreasonable? At least at this point. It might have become unreasonable before that. It might have been unreasonable before that point. But it was at least unreasonable at that point, which makes total logical sense to my mind. After that point, because of the policies, because of law, right? There's no resistance, and the policies require you to move him in a position. There's no particular reason not to, and so it makes perfect logical sense that at that point, especially if you're making an active decision, it becomes objectively unreasonable. Defendant admits that in this, using this unreasonable and excessive force, he acted willfully, so he did it intentionally, and in callous and wanton disregard of the consequences of life. So he used the excessive force itself willfully, intentionally, and as to the consequences, he just didn't care. That's what it says. The defendant knew that what he was doing was wrong, in part because it's contrary to training. Defendant chose to continue his use of force even though he knew policy and training that once Floyd was compliant, the defendant should have gotten off him and moved him to a side recovery position. Again, this is all going to his knowledge and intent. He knew the policies. He knew he should do this. He intentionally decided not to do it. Defendant also knew There was no legal justification to continue use of force because he was aware that Mr. Floyd not only stopped resisting, but also stopped talking, stopped moving, stopped breathing, and lost consciousness and a pulse. So, yeah, somewhere in that interval, if not before, it became unreasonable to continue using force and not administer first aid. The defendant chose to continue applying the force even though he knew Mr. Floyd's condition progressively worsened. The defendant also heard Mr. Floyd repeatedly explain he could not breathe, was in pain, and wanted help. Likewise, the defendant knew what he was doing was wrong. The continued force was no longer appropriate, and it posed significant risk to Mr. Floyd's life, based on what he observed and heard about Floyd. The defendant was aware that civilian bystanders repeatedly asked him to check for a pulse, so he heard that, stated that Mr. Floyd was unresponsive and not breathing, and asked him to get off Mr. Floyd. So the entire crowd is telling him and giving him active knowledge, right? Yeah, the defendant also heard Officer Kung, who checked Mr. Floyd's for at least twice for a pulse, twice saying he could not find one. Active knowledge. Defendant did not observe Officer Thao or Kung do anything or say anything to try to get the defendant off Floyd. Defendant heard Officer Lane twice ask whether they should be rolled onto his side. Should we move him into this recovery position? The defendant did not hear or observe Officer Lane press the point, and did not hear or observe Officer Lane say or do anything to try to get Officer Kung and the defendant off of Floyd. Defendant did not ask or direct Officer Kung to discontinue the restraint of Floyd. In addition to willfully depriving Floyd of his constitutional rights to be free from the use of unreasonable force by a police officer, as detailed above, the defendant also willfully violated Floyd's constitutional right not to be deprived of liberty without due process of law, which includes an arrestee's right to be free from a police officer's deliberate indifference to serious medical needs. Yes, this is yet another standard, right? Deliberate indifference. This goes to his knowledge, or his duty, his affirmative duty to act, right? It's not much. You have to have deliberate indifference. So you have to not care deliberately. It's usually pretty hard to meet that standard, right? Because usually police officers are doing any number of things that might show they care. They might not necessarily be the most effective things. They might not necessarily be doing all the things, but usually they're doing something, anything, right? And what was Chauvin doing? Shit all. What was Chauvin doing to try to get Floyd assistance? Fuck nothing. None of the things. No things. And he knew about it because, again, being told by the crowd, being told by his fellow officers, being told even by Floyd, being told by literally the world. And he's just sitting there deliberately, intentionally, indifferently. Yeah, I mean, you're there without breaking a sweat on the law. Which includes an arrestee's right to be free from police officers' deliberate indifference. Defendant admits that he failed to render medical aid to Floyd, as he was capable of doing and trained and required to do. Defendant heard bystanders offering to provide medical aid and did not permit the bystanders to permit Floyd. At the time, defendant failed to render medical aid to Floyd. The defendant saw Floyd lying on the ground in serious medical need and eventually unconscious and pulseless, and recognized Floyd was in clear need of medical aid. This is like not a ambiguous condition. This is all knowledge that you had that was ongoing, not for the least of reasons that your fellow officers are telling you they can't find a pulse. At no point during the entire period with Floyd on the ground, defendant or anyone else move Floyd onto his side, start CPR, or provide medical aid of any kind to Floyd. Defense failure to render medical aid resulted in Floyd's bodily injury and death. I mean, yeah. It definitely led to injury. So, yeah. Defendant agrees the appropriate base level offense is second-degree murder. Because he used unreasonable and excessive force that resulted in Mr. Floyd's death, they acted willfully and callously, wanton disregard of the consequences to Floyd's life. Defendant admits that his willful use of unreasonable force resulted in Mr. Floyd's bodily injury and death because his actions impaired Mr. Floyd's ability to obtain and maintain sufficient oxygen to sustain life. Okay, so at this point in the discussion, I feel obligated to talk about the fentanyl use and the drug use, because there are a lot of people who are convinced that Mr. Floyd died of drugs. And I would like to, again, tell you about the law. So, okay, Mr. Floyd had drugs in his system. It was several times the amount that is listed as the LD50. So the LD50 is the lethal dose 50%, right? So what amount would it take to kill a normal person, the average normal person? How much would you have to take to have a 50% chance of it killing this normal person? So that's the LD50, right? So he was a couple times beyond the LD50. How many times beyond the LD50 is debatable, depending on exactly who you ask, but it was a multiple, somewhere like 3 to 12 times. But of course, Mr. Floyd isn't a typical person. Mr. Floyd is a habitual user of this drug, and you become more and more tolerant to the drug. You can definitely still overdose, but you become more tolerant. So the LD for Floyd is less than it would be for a normal person, or more, whichever way makes it. Yeah, he would have to take more in order for it to be lethal to him as opposed to a normal person, because he has some built-in tolerance. Okay, so there's that factor. Now, let's assume that despite all that, that Floyd died from the fentanyl. Okay, because, I mean, that's a possible thing. He had a dose that was a couple multiples, so how much could it be beneficial, right? So I think it's reasonable. I think it's reasonable to conclude that Floyd died from a fentanyl overdose. But here's the problem. He also died from Chauvin. The two are not mutually exclusive. This is a thing that I think people miss on the whole Chauvin thing. It can be multiple causes, either one of which, incidentally, standing by themselves, could be sufficient. So it could be sufficient by themselves, either one. But the fact they're acting in concert is irrelevant, particularly as it relates to Chauvin, because all we need for Chauvin to be guilty is to show that Chauvin is a substantial causal factor. Not the primary factor, not the dominant factor, not the major factor, not the sole factor, a substantial factor, a non-negligible factor. A non-negligible factor. Is Chauvin a substantial factor in Floyd's death? Is he a non-negligible factor in the death? And my answer to this question is yes, he is. He is. Now, of course, people at this point will say, well, the drugs are a problem because by being on the drugs, it made it easier for Chauvin to kill him. So what Chauvin did wouldn't kill a normal person, they say. It only killed Chauvin because he was on the drugs. If he wasn't on the drugs, what Chauvin did wouldn't have killed him. Okay, let's assume that's true. Let's assume that's true. Let's assume that if George Floyd wasn't on drugs, or it was someone else who wasn't on drugs, let's assume that if he wasn't on drugs and Chauvin did exactly what he did, that it would not kill that person. Okay? Assumption. Does it matter? And the answer is no, it doesn't, because we're not talking about anyone else. We're talking about Chauvin on the drugs. But he willfully took the drugs. He did it illegally and intentionally. Right. Correct. It doesn't matter. This is eggshell skull doctrine. This goes as deep in law as you like. You know, when you commit a crime against a victim, you accept the victim as you find them, in whatever condition they are, whether it was self-imposed or not. You take the victim as you find them. You're the one committing the crime. You're the one taking the gamble. So it could be a particularly resilient person. It could be a particularly resilient person, and you do things that would kill an ordinary person and it doesn't kill them. You know, hey, you got lucky. You got lucky. And you're going to be, you're not going to be guilty of murder because they didn't die. So, you can get lucky. The person's particularly resilient, and it helps them. But you can also get unlucky, and that's kind of what happened here. Chauvin was in a weakened condition. He was in a weakened condition because of illegal acts, namely taking drugs. He was in a weakened condition because of his intentional illegal acts that weakened his physiology. But it doesn't matter, because Chauvin takes him as he finds him. So if Chauvin, if it wouldn't kill an ordinary person, but it would kill Floyd, murder. So all you have to conclude for Chauvin to be guilty is that he is a substantial factor. You don't have to conclude that drugs didn't kill him. You can conclude drugs killed him. That's fine. The only question you have to ask yourself is, did Chauvin also kill him? And was he a substantial factor in that? And it's like, well, what are some of the symptoms of fentanyl use? Well, it makes it harder to breathe and, harder to have oxygen, causes heart problems. These are some of the symptoms of fentanyl. He was on an elevated dose, remember? He was on an elevated dose. That's your guy's argument, remember? He was on an elevated dose, so probably reasonable to suspect that he was having these symptoms. Right? He was probably having problems breathing, probably having problems with his heart. Probably a problem. And then this guy over here puts him on the ground with his stomach on the ground, so, his lungs can't expand, and keeps it there as he slowly suffocates. So, that's murder. It's murder all day long. Doesn't matter that he was on fentanyl. Doesn't matter that the fentanyl was illegal. Doesn't matter that the fentanyl killed him. Doesn't matter that it was self-inflicted. Doesn't matter that he weakened himself. The only thing that matters is, did Chauvin, with this weakened, conditioned person, did Chauvin, with this weakened person, do stuff intentionally that brought about the death as the result of that stuff? That's murder. It's murder all day long. Hopefully this is helpful. Also, incidentally, for what it's worth, just as another aside, although it would be difficult to prove in law, but is a theoretical matter. If you could prove for an absolute certainty the fentanyl alone would have killed him 1 second later than he died. So if you could prove for an absolute certainty the fentanyl would have killed him 1 second later by itself, right? So 1 second later, he would have died just from the fentanyl use. As long as Chauvin was the reason that it was 1 second, at least a substantial reason. As long as Chauvin is a substantial reason, it's 1 second earlier than it should have been. That's murder. That's murder all day long. You don't get to rob someone. You don't get to make a decision that robs someone of 50 years of life, and you don't get to make a decision that robs someone of 1 second of life. That was their 1 second, not yours. So even if the fentanyl acting alone would have killed him 1 second later, no one cares. No one cares about what happened 1 second later. The only question is, was he a substantial factor at that moment? And you're there, in my humble opinion. So hopefully all that was helpful. Oh, and people are pointing out he was fighting the cops. I'll just respond to this point. Yeah, fentanyl causes a whole bunch of symptoms. Fentanyl causes aggression, which is not atypical. So yeah, at the same time, it causes aggression and fighting behavior and makes it easier for a person to fight because they're high on an opiate, which is a painkiller among other things. So in the same way that it makes it easier for the person to fight and easier for them to struggle back, it also has deleterious effects on the heart and lungs. So even as it's a painkiller, making it easier for you to fight and giving you the courage to fight because you're stoned out of your brain and don't care, and there's less pain. It's also weakening you by hurting your heart and hurting your lungs, among other problems. So raising your blood pressure and so forth and so on. So fentanyl has many effects. Don't do drugs, kids. All right, so let's talk about this other incident that happened that he's also being convicted of. On or about September the 4th, 2017, in the state and district of Minnesota, again, by district, we mean federal district, The defendant, while acting under color of law, willfully deprived juvenile 1 of his constitutional rights, specifically the right to be free from unreasonable seizure, which includes the right to be free from the use of unreasonable force by a police officer. First, the defendant, without legal justification, held juvenile 1 by the throat and struck juvenile 1 multiple times in the head with a dangerous weapon, resulting in bodily injury to juvenile 1. Second, the defendant held his knee on the neck, shoulders, and upper back of juvenile 1, even after juvenile 1 was lying prone, handcuffed, and unresisting, resulting in bodily injury. This wasn't Chauvin's first time. Specifically, the defendant admits that on September the 4th, 2017, he was on duty and acting under color of law as a patrol officer in the MPD in the city of Minneapolis and District of Minnesota. The defendant and a second officer who was being trained by the defendant that day responded to a domestic assault call at a residence of Minneapolis. Upon arrival, they spoke with the caller, who reported that her 14-year-old son, the juvenile, had assaulted her. After the officers took the report from the mother, she showed them to a bedroom where juvenile 1 was lying on his stomach on the floor playing with his phone. At no point in the encounter did juvenile 1 use force or threaten force against the officers. Throughout the encounter, the defendant was aware juvenile 1 was 14 years old, and juvenile 1 made no aggressive movements towards the officer. As the officers began to take juvenile 1 into custody, juvenile 1 attempted to explain the situation with his mother and pulled away. After this initial encounter, the defendant used unreasonable and excessive force on juvenile 1 by striking him in the head multiple times with a police-issued flashlight. Ouch. The defendant then pinned juvenile 1 to the wall by his throat and again struck juvenile 1 in the head with his flashlight. Defendant's strike caused a wound near his left ear. The defendant admits that he used unreasonable and excessive force on juvenile 1 by holding his knee on the neck, shoulders, and upper back for between 15 and 16 minutes. During this period, juvenile 1 was face down on the floor, handcuffed and unresisting. During defendant's restraint, juvenile 1 cooperated with the police and at times cried from pain. So this might be exactly the example, right? So juvenile 1 didn't die from it. Juvenile 1 didn't die from this procedure, being handcuffed on his neck and back. It didn't cause his death. So when Chauvin took that victim as he found him, didn't work out so bad for Chauvin because the guy didn't die. He beat the crap out of him and committed all kinds of violations of law, but, not so much with the death. So there's that. Juvenile 1 wasn't in a weakened state. You got lucky. Floyd was in a weakened state. Sucks to be you. Don't commit crimes. See, if you don't commit crimes against people, you won't have to worry about these problems. The defendant admits his use of unreasonable force was willful. He was trying to do it. Throughout his experience as a police officer, the defendant was familiar with the policies and training regarding authorized use of force, including the requirement on officer use force only in proportion to subject's resistance, and requirement that an officer stop using force when a subject is not resisting. In particular, strikes to the head are considered deadly force. Damn straight. 100% straight. We covered this in Kyle Rittenhouse, man. It's quintessential grievous bodily harm. Quintessential grievous bodily harm. It's deadly force. Strikes to the head. Yeah. With the skateboard on Rittenhouse. We covered this again. Yeah, it absolutely is. Because you can get traumatic brain trauma fairly easily. So, yeah, you can get And deadly force may only be used when a person presents risk of death or great bodily harm to the officer. The defendant was also trained that if an arrestee is in the prone position, the position makes it more difficult to breathe, and thus officers should move the arrestee to a side recovery or seated position. The defendant's use of unreasonable force was willful, as evidenced by the report. Defendant wrote about the incident in which he admitted that he repeatedly struck the juvenile in the head with a flashlight, grabbed him by the throat, and used his knee. So he filed a false police report, which is also incidentally illegal, but also shows consciousness of guilt. And this resulted in bodily injury. So those are the two incidences that we're going. So propensity evidence is okay to use against Chauvin? No. These are two separate crimes. Yeah, you might have misunderstood what was going on. But it was a great question. No, this isn't propensity evidence. We're charging him with both crimes. Yeah, we're not using this prior incident to prove this incident. We're charging him with both offenses. They're both within the statute of limitations. It was 2017, and the federal government has a 5-year statute of limitations. So it was within the statute of limitations. They're two separate offenses. It's not propensity evidence. They're two separate crimes. So hopefully that was clear. And I'm glad I caught that so I could address that in the chat. Defendant agrees, and the defendant understands and agrees defendant has certain rights to file pretrial notices in these cases. As part of the plea agreement and based on concessions of the United States within this plea agreement, defendant knowingly, willingly, and voluntarily gives up the right to have any pending motions resolved because they would be mooted, and file any additional pretrial motions in these cases because there's no more case, because it's over, because guilty. Defendant agrees that by pleading guilty, he's withdrawing any motions previously filed, which, yeah. The defendant understands that as a result of his conviction, he could be assessed the cost of prosecution and experience additional consequences, such as the loss of the right to carry a firearm, the right to vote, and the right to hold public office. Yeah, you need to inform people of this. It's like, yeah. The defendant understands that he has the right to go to trial. At trial, the defendant would be presumed innocent, have the right to a trial by jury, or with consent of the United States and of the court to trial by court. So in the United States system, you have to get permission from the prosecutors if you want to go to a bench trial. This is not necessarily the case in all states. The right to assistance of counsel, the right to confront and cross-examine adverse witnesses, the right to subpoena witnesses to testify for the defense, the right to testify and present evidence, and the right to be protected from compelled self-incrimination. Defendant understands that he would have the right to an attorney at every stage of the proceedings, and if necessary, one would be appointed to represent him. Defendant understands that he has the right to persist in a plea of not guilty, and if he did so, would have the right to a public and speedy trial. By pleading guilty, defendant knowingly, willfully, and voluntarily waives each of these trial rights except to the right of counsel. Defendant understands that a guilty plea is a complete and final admission of guilt, and if the court accepts the guilty plea, the court will adjudicate the defendant guilty without trial. Okay, here are the potential statutory penalties. So remember, two different crimes, so two different possible penalties. So as to count one of the indictment, which is with Floyd, the 242 violation is a felony offense that carries the following potential penalties under statute: a maximum of life imprisonment, a supervised release of not more than 5 years, a maximum fine of $250,000, assessment to the defense of the cost of prosecution, imprisonment, and supervision, so he has to pay for his own imprisonment, and a mandatory special assessment of $100, which I don't know where the special assessments come from, but they always crack me up, because who cares about the $100, but whatever. Defendant understands that count one of the information, now this is referring to the juvenile offense, right? We went from indictment to information, of 242 is a felony offense that carries the following: a maximum term of 10 years in prison, the principal difference being, of course, someone didn't die from it, a supervised release of not more than 3 years, a maximum fine of $250,000, assessment to defendants, cost of prosecution, imprisonment, and supervision, and a mandatory special assessment of $100. Therefore, under the terms of the agreement, the total statutory penalties are a maximum of life imprisonment, a supervised release of not more than 5 years, a maximum fine of $500,000, assessment to the defense of costs of prosecution, imprisonment, and supervision, and a mandatory special assessment of $200, because that's 100 plus 100. The defendant understands, excuse me. The defendant understands that if the defendant were to violate any condition of supervised release, the defendant could be sentenced to an additional term of imprisonment up to the length of the original supervised release term. So if he violates any supervised release, he can be sentenced to anything that he didn't serve from the good behavior from before. And incidentally, the United States federal government does not have parole. It's not a thing. That you can get off early due to good behavior. I believe it's a 20% credit, if memory serves correctly. So you can, in practice, shorten your sentence by 20%, I think. It's either that or 15. It's one of the two. But yeah, you can reduce your sentence by 20% for good behavior. But they don't have parole. It's just not a thing. Okay, the parties acknowledge the defendant will be sentenced in accordance with the relevant law. Nothing in this plea agreement should be construed to limit the parties from presenting any and all evidence to the court at sentencing. The parties also acknowledge the court will consider the United States sentencing guidelines in determining the appropriate sentence. So yeah, the U.S. federal government, like many states, has a sentencing guidelines, and they are guidelines, but they're fairly strict in the federal system. The parties stipulate to the following guideline calculations. Count 1 of the indictment. The parties agree that pursuant to the United States Code, the base level of the offense is 12, or the base level offense for the underlying offense. So it's deprivation of rights under color of law, or apologies, not under color of law, based on race. So the deprivation of rights based on race is offense level 12 in and of itself. Of course, the underlying offense in this case is second-degree murder. So the base level offense for that is 38. So 38 is your base level offense. The parties agree that the offense should have an increase of 6 levels for color of law. So because you're a police officer, an additional 6. I'm not sure where they came up with that number, but that's what they agreed to. The parties agreed that the base offense level should be increased by 2 levels for restraint of the victim. As to the information, that's the juvenile offense. The parties agreed pursuant to the code that the base level offense is 10, or of the underlying offense, which this case is aggravated assault, which is 14, therefore it's 14. The parties agree that the offense level should be increased by 4 levels for use of a dangerous weapon, which in this case would be the flashlight. The parties agree that the base offense level should be increased by 3 levels for the bodily injury. The parties agree that the should be increased by 6 levels because the offense was committed under color of law. The parties agree the base level offense should be increased by 2 levels because the defendant knew the victim was particularly vulnerable. So in that case, he knew it, as opposed to it just being a fact that exists. The parties agree that the offenses charged with the indictment and information are not grouped, which results in 2 units. The parties agree that the offense level will not increase because of one unit is over 9 or more levels less serious than the other unit. This results in an offense level of level 46. So this is basically saying that the offenses are not grouped for the purposes of determining a new offense calculation as them collectively. So they are still considered separately. The United States agrees to recommend a 3-level reduction for acceptance of responsibility and make appropriate motions with the court. However, the defendant understands and agrees the recommendation is conditioned upon the following. Defendant testifies truthfully during the change of plea hearing. Defendant cooperates with the probation office for the pre-sentence and investigation, and the defendant makes no statements and commits no further acts inconsistent with this acceptance of responsibility. If the defendant receives this 3-level adjustment, then the final adjusted level will be 43. Based on the information available at this time, the parties believe that the defendant's criminal history category is level 1. That is, he has no criminal history. This does not constitute a stipulation, but a belief based on assessment of it currently known. It's definitely level 1. The defendant's actual criminal history will be determined by the court based on information presented in the pre-sentence report and by the parties at the time of sentencing. If it is determined the defendant's criminal history is other than Category 1, such determination shall not be the basis for either party to withdraw. So if it turns out that you have a higher offense category, you can't withdraw for that reason. If the defendant's adjusted offense level is 43 and his criminal level is 1, the advisory guidelines range is life imprisonment. So if we are correct in our calculations, which I'm sure they are, I'm sure they are. They do their best, and they're not like trying to hide the ball. So, So they say, well, if it's level 43 and with a prior history 1, then the guidelines say life. So, incidentally, the statute allows for any term of years. So it allows for any term of years or life or even the death penalty, which obviously wasn't an issue here, or at least didn't become an issue. The sentencing guidelines for the fine is a range of $50,000 to $500,000. That's a lot of range. The sentencing guidelines require a term of supervised release of at least 2 years, up to a maximum supervised release of 5 years for count 1, and a term of 1 year up to a maximum of 3 years for count 1 of the information. So 2 years to 5 years of supervision if you get out of court. The following stipulations are binding on the parties, but do not bind the court. The parties understand the sentencing guidelines are advisory, and their application is a matter that falls solely within the court's discretion. Correct. Right? The sentencing guidelines are advisory. It's strongly advised. in the federal system, but they're still technically advisory. The judge can sentence you to, anything within the range. Technically, he has to justify it, which makes it, you won't go out of your way for it, but the parties understand that it's advisory. The court will make its own determinations regarding the applicable guideline factors and the applicability of criminal history category. If the court determines the applicable guideline calculations or defendant's criminal history is different from that stated above, the parties may not withdraw. So if the court comes to some separate conclusion, that's not a basis. I'm sure they're right, though. Based on the facts and circumstances of these cases, the United States and defendant agree, pursuant to federal law, the following disposition of the case is appropriate. So this is what they're saying that they want to agree to in terms of punishment. The court should impose a sentence of imprisonment of no less than 240 months and no greater than 300 months, expected to serve no less than 204 months, and no greater than 255 months, assuming all good time credit, which is what I referred to. So that's basically 25 years. The court should impose a 5-year term of supervised relief. The court, pursuant to law, should order the sentence of imprisonment imposed in this case to be served concurrently to the 270 months. So he got 22 and a half years in the state system, and he can get 300 months in the federal system, up to, but they want to serve him concurrently. They're to be served at the same time, regardless of where he's being held, incidentally. The court, pursuant to law, should order that the sentence of imprisonment imposed in this case be served concurrently to the 270 months, which is expected to be 178 months, assuming all good time credit. At sentencing, the court, pursuant to law, should adjust the sentence for any period of imprisonment, incarceration already served in the case, listed in the previous subcategory, so he gets all credit for all time already served, which of course you do. The parties understand that if this plea agreement is accepted by the court, the agreed disposition set forth will be binding on the fourth, will be binding on the court. So if the plea agreement is accepted, if it's accepted, then the agreed disposition is binding. So yeah, there's a federal rule that allows for this. There's a federal rule that allows for this. Not true in all state systems, incidentally, and not even true in all cases in the federal government. But there's a kind of plea deal that binds the court because it's part of the deal. And you're saying one of the things is contingent on the court agreeing to it. So they also have to be an agreed party. And if not, the plea deal falls apart. So, that's an option in the federal system. So that's what they're doing here. The parties agree to advocate for this as set forth. Specifically, the United States intends to advocate for a sentence of 300 months. The agreed sentence is based upon the consideration of the sentencing factors set forth. The parties acknowledge and agree that under the rules, it's limited to issues set forth in paragraphs 10A, 10B, D, and the stipulation has no effect on court's authority and discretion to impose a fine, restitution, or any and other all applicable penalties as a result of the conviction. If the court declines to accept this plea agreement and the agreed upon sentence, either party may withdraw. So, sentencing hasn't happened yet. Won't happen for a couple months. But, if at the end of the day, the court says, I'm not feeling it, then both sides are free actors. And they can reach new agreements or not. But, you would expect the court to say yes, although they might say no, because, the guideline range are the guideline range, and you're asking for quite a deviation. So, although, again, no one's going to appeal, right? So that's the thing you really are worried about in that position, right? You're worried that someone's going to appeal. So it might be straight. It might be a significant deviation. It might not withstand appeal, but no one's going to appeal. So what do you care? Yeah. And you have to pay us the $100 thing, which, whatever, that's fine. The defendant understands and agrees to pay restitution pursuant to law, and the court may order the defendant pay restitution to victims of the crimes. The parties agree that Floyd and Juvenile 1 are identifiable victims who have suffered physical and pecuniary loss. Pursuant to law, the defendant agrees to pay restitution in an amount to be determined by court sentencing. So he has to pay them for restitution. So this quashes presumably any civil case, because you're going to get basically all you need from the criminal judgment. I can order restitution and make you whole. whatever that number is. So, yeah, okay. Not that I think George Floyd, I apologize, not that I think Chauvin has a particular amount of money, and the city's already settled. So, what are they going to take from him? His 13 cents an hour as he's working the prison laundry or something? There's presently no agreement as to the amount of restitution. What does it matter? It's basically infinite from his point of view, I would imagine. The parties agree that procedures for the issuance and enforcement of this is pursuant to other law. The defendant agrees to have no contact directly or through third parties with the victims of his crime, including juvenile one and the estate or family of Floyd, while in the Bureau of Prisons custody or during any period of release. So, no contact for you. The defendant understands and agrees that as a convicted felon, he will never be eligible to work in any law enforcement capacity, even once he's served his substantial prison sentence. Accordingly, the defendant expressly agrees to permanently forfeit any law enforcement and correctional officer certificates with the Minnesota Board of Peace Officer Standards and Training and any other law enforcement certifying agency to which he possesses a current law enforcement or correctional officer certificate via written notice. So he has to surrender all that stuff, assuming that hasn't already been happened. And then, of course, the defendant will fully and completely disclose the existence and locations of assets, including held by a spouse, nominee, or third party, blah, blah, blah. Defendant agrees to waive appeal and any collateral attack, so long as the sentence is consistent with paragraph 10, and waives the right to appeal guilt or innocence, sentence restitution, blah, 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 blah. And the defendant has agreed to this with his attorney. Defendant understands rights being waived. Defendant waives those rights knowingly, intelligently, and voluntarily. The United States has agreed to waive its right to appeal any sentence so long as it's consistent. The defendant waives his right to any FOIA requests consistent with this case. And this is the entire agreement. There is no more. And then Chauvin's signature is apparently a water bucket with a drop of water coming into the bucket. So, okay. I mean, apparently that's how he signs his name. So, yee. So all that stuff. So, all those things. So let me answer some questions. From the chat. Okay, let's see. $2 from John Cook. Poison myself and pick fights. I make my murderer? Maybe. Depending. Possibly, yeah. I mean, you need to know a little bit more on the facts, but yeah, if you poison yourself and you pick a fight and the fight is, going for a while and then you surrender and give up and they continue to punch at you even as you continue to surrender and give up and they continue to do stuff and then you die, yeah, that would be what murder looks like, sure. Okay, fair enough. Is the FOIA clause normal? I've never really seen it, but Kung is pronounced King. Minnesota's Sun says run concurrently. Well, they might, but they're all part of the same constituent. No, they don't. They run concurrently. They're right. I always get them confused. Yeah, they run concurrently. That's true. The Minnesota census run concurrently. That's right. Azra said, if that was the standard, there's literally nothing Chauvin could do where you couldn't make the argument Chauvin was an A factor. Walking away, not giving water, all my kill. Well, that's why it has to be a substantial factor, not just a factor. It has to be something of substance. It has to be non-negligible. So it's not quite as trivial as you imagine. So also requires the intent behind it. So for the underlying intent of the aggravated assault. So the felony murder was the intent was for the felony assault. So nothing there would be an example of felony murder. So it wouldn't be a second degree murder. It might be some other lesser crime, but it wouldn't be that. Learning the ropes gives me $20. Says, thank you for the $20. Nice job tonight. My bet is his first appeal will be for ineffective counsel. Cute. Cool Frog says, don't forget to bring up that AG Barr denied Chauvin to plead guilty the first time. Will his criminal level history be higher in the fraud charges now? I honestly don't know. If this did go to trial, could the prosecutor file the state transcripts as evidence? I think technically, yes, only if the witnesses aren't available. But if the witnesses are available, then no. So yeah, that's all the things I have to discuss. So we can talk for a couple of minutes about the underlying, state conviction. If you guys like, because I try to answer some questions on it. So yeah, you have a duty to act, but that duty to act may not necessarily be criminal. It may be civil. And so like failing to give water might be a civil violation, but in this case, the reason it was murder too was because of an aggravated felony, and the aggravated felony is intentional. So your examples wouldn't lead to a murder two conviction. There might be some lesser criminal charge, but absent something fairly extreme, you wouldn't expect that. He does not have the opportunity to appeal, no. The combination of fentanyl, meth, cocaine, and weed in his system, that's what killed him? It might very well have. The question is, did Chauvin accelerate that process? Did Chauvin accelerate that process by doing all the things that were said? Did Chauvin aggravate that? And if so, you're there. Does it block 42 U.S.C. 1983? Well, 1983, I don't know. As to the city, they've already settled. As to him, I don't know. But they're already getting redress in the criminal case. So I don't think there's a viable 42 U.S.C. 1983 cause of action. The coroner's report said he died of a drug overdose. They mentioned that in part. Yeah, they also mentioned the knee on the neck and other stuff. It's not clean. There's no coroner's report that says the sole cause of death was the fentanyl. They mention it. They mention it as a factor in his death. They mention the amount of fentanyl and stuff in his system. They mention that the amount was several times the LD50 number. So, I mean, they mention all those factors that were part of his death. So did they contribute to his death? Yeah, almost certainly. Almost certainly they contributed to his death. The question isn't whether or not the drugs contributed to his death. The question is whether Chauvin was a substantial contributor to his death. And if the drugs made him more vulnerable, then, too bad for Chauvin. How can I be sure they aggravated beyond a reasonable doubt? I mean, because I watched the tape. And so did you. I mean, you don't have to find much, right? You just have to find he's a substantial factor. Which is, how do you find substantial factor by a reasonable doubt? I mean, I'm there. I mean, we know that, and the medical testimony was there. We know that the fentanyl and the drugs cause problems in the respiratory system. We know he has heart problems. We know he has, problems at that moment from higher blood pressure and heart conditions related to the drugs. So we know all those things. But we know that also Chauvin was putting weight on his back and pressing his chest cavity into the hard, unforgiving cement, which kind of makes it harder to breathe. So if you're already having trouble getting oxygen into your body from the drugs that you took, and now you put them on the ground, and you press their entire chest cavity into the cement, does that make it more hard to breathe? Yeah. So I'm there. I'm there. And also, as someone in chat points out, it's not like interacting with people on drugs is unknown to the police. So, $9.99 from Johnny Face. Lying on a police report shows consciousness of guilt. It can. Does this include lying by omission, such as failure to file use of force report? Yes, it can. Yes, absolutely. Body cams demonstrate it seems to happen often. Yeah, that could be shown as a consciousness of guilt. By your logic, simply handcuffing him is murder. No, it's not. It's completely different. By simply handcuffing him, it doesn't restrict his chest cavity. I don't know why this is... the two are completely different. If you handcuffed him, his hands are behind his back. His chest cavity isn't restricted by putting his hands behind his back, so that wouldn't be an aggravating condition that would make it more difficult to breathe. If you're putting him face down and stomach down on hard, unforgiving cement and pavement and pushing his entire chest cavity wall into the pavement, I think that's quite a bit different than merely being handcuffed. Yeah. If someone just stepped off a ledge of a building and you pushed them at the same time, would that be a crime? If you push them at the same time, if you could prove it. So your hypothetical is someone is voluntarily making a decision to jump off the building, as I also simultaneously am pushing them off the building. And you can prove that. How are you proving this? Yeah, probably. I mean, if we assume that you pushed hard enough for him to fall, then yeah, I think you're there. Yeah. The amphetamine caused increased blood power. Fentanyl lowers it. I appreciate the medical correction. Which leads to its own set of problems, incidentally. For having lower blood pressure can also present problems. Yeah, high blood pressure is bad. Low blood pressure is bad. Having both high and low blood pressure at the same time is also bad. It's got to cause stress on the system. Do you, Nick, or Nate have a breakdown video of the Chauvin verdict? I've been long found the verdict questionable, but I'm hearing things that might change my view. I don't know if I've done something like that on my channel specifically, but yeah, the law is fairly clear. You can't deprive someone of 1 second of life. That 1 second is theirs, not yours. You know, you can't be a substantial contributing factor to their death. If the fentanyl would have killed them 1 second later, and was partly responsible for killing them at that moment, and you're also a substantial partial cause, which is hard not to believe. You know, from the pushing the cavity wall into the cement, and you know, it's like, well, we know he did those things. That he pushed it in. And it's like, well, that's an aggravating factor. It's like, yeah, I'm there. Yeah. Yeah. So the jury could have concluded Chauvin was 10, 20, 30%. Yeah, something like that. I mean, substantial factor is not exactly defined, but 20% is probably good. It's like, is he 20% responsible? It's like, yeah, that's all you need. You know, the other 80% was done by the drugs, but you know, you helped him across the line. That'll do it. Manuscript question from Ann Feinstein. Juvenile witness tells detective he's not safe at home. What is detective's duty under law? None, I don't think. The police officer, yeah, because who would he report to? Like, he's a mandatory reporter, but who would he report to? He's the person to report to. So, probably no duties. Not for the least of reasons that the police officer might not believe him. Like, so if like a psychiatrist or a school official comes into that knowledge, they have a mandatory reporter duty. But as to the police officer, I don't think he has a duty at all. I think he's in the clear. CPS? Okay, well, in that case, if he's a mandatory reporter to CPS, then he's a mandatory reporter to CPS, so failure to report would be a problem. Okay, fair enough. I stand corrected. The Real Hollister said, hello, Uncivil. Just want to point out something minor from the legal bite stream. Not a doctor, but I know birth control has a lot of side effects. For instance, Zeppo shot leaches calcium from the bone. This is fair. I think the risk factors are low enough, in my humble opinion, for it to be over the counter. Although, of course, those factors should be disclosed. But yeah, I might have undersold the potential repercussions from birth control. So I do appreciate the thing. Chauvin hasn't been sentenced in this case yet. They're recommending 25 years, but he hasn't been sentenced yet. But I think 25 years is highly likely. And the language of the agreement implies, although it doesn't say it, the language of the agreement implies that he would serve his time federally, which, incidentally, if you ever get the choice, the consensus opinion is that federal prisons are better than state prisons. So, you know, if you ever get the option, federal prisons are probably the way to go. Just saying. Anything else? I think Chauvin's lawyer was pretty terrible during trial. I don't think so. I thought his lawyer did. I mean, he wasn't great. He wasn't stellar, but I thought he was doing a fine job. I didn't have any super major criticisms. I thought, you know, he was doing a competent job. When do we know when Jussie is being sentenced? No, not off the top of my head. I think it's January, if memory serves. I believe he's being sentenced in January. I'm not sure about Chauvin here. Anything else before I end the stream? Okay, yeah. John Boyd is either misremembering or misquoting. So this is a good point to correct. And I'm not intending to be harsh on you here, John. I just want to correct the record on this. So John Boyd said, medical examiner even stated that if Floyd would not have been in police custody, death would have been easily ruled cut and overdose. That's not what he said. He said something more precise to a much more precise question. What the medical examiner said, and you can go watch the tape for yourself and know and just see what I'm not making it up, because I mean the whole thing's on YouTube. But what the medical examiner was asked was, if you came upon a body, and I'm paraphrasing, obviously, but the question was, if you came upon a body that was dead and there were no other indications of a cause of death, right? There are no other indications, but you knew that he had this amount of fentanyl in his body, would that be reasonable to list as a cause of death? And he's like, yes. In the absence of anything else, correct. Right? So yeah, if all I know is he has this amount of drugs in his body and he's dead, and like the amount is fatal, then it would be perfectly reasonable to conclude the drugs killed him. In the absence of anything else. But that's part of the predicate of the question. Right? If nothing else was true, would you be able to draw that conclusion? Sure. Here he had a lot of other information though, which necessitated different conclusions. So that's a little bit, going to correct that. Why is Smollett not in jail until sentenced with felonies? I think because the sentencing guidelines recommend probation, but I'm not even sure if the defense asked. If the video and blind inspection lead to different conclusions, does that invalidate the profession looking at bodies? Absolutely not. No, absolutely not. As a professional in any field, you want all the information you can get. Of course you do. Like, the more information you have, the better it is to form your conclusions. So, like, if all I know is the toxicity, well, the toxicity, right? If all I have is the body, then I can look at the body and draw a bunch of conclusions. If I have the videotape of the thing happening, well, that gives me a shit ton of information, now doesn't it? For me to now inform my opinion better. So no, it doesn't invalidate it. It's just more information. It's like looking at the body alone only can tell me so many things, but now I have a video of it happening, that tells me more things. So it's not invalidating. No, I disagree with it completely. Alexandra Wagner says, many seem to argue that it can't be culpable negligence if something is a mere mistake. So let's say you miss the speed limit, so I won't get you convicted of manslaughter. I think that's true. Yeah, I think that's true. Yeah, mere negligence that's right. That's right. I think manslaughter everywhere requires recklessness anyway. So yeah, I think that's right. Will the post office bring mail fraud charges to Smollett? I don't know. Yeah. All right, I'm going to sign off for now because there doesn't seem to be any more questions, but I've really appreciated doing this, and I hope this was helpful. And I hope I helped correct the record a little bit on some of the law as it relates to Chauvin. I think the jury came to the right conclusion. I mean, I listened to a fair amount of the trial, and the medical testimony was persuasive, and the video was persuasive, and it's like, well, given the law. Now, incidentally, for what it's worth, I disagree with aggravated felony being a predicate felony for felony murder. I think that's bullshit, but it's the law. So I don't think, as a matter of policy, that's good policy, but it's the law. So, you know, I don't approve of using the underlying assault as the predicate felony for the murder. To my mind, doesn't make sense. When I first heard about this, when I first saw that in Minnesota law, I'm like, that can't possibly be true. And then I went and read 5 Minnesota Supreme Court cases before I was convinced it was true. Because even after I read the first one, I'm like, they didn't mean that. Even after I read the second one, they didn't mean that. And I had to read 5 of them. Before I was like, okay, they probably meant it. So because it threw me for such a loop. But yeah, that was, I don't approve of that, but that is the law. So anyways, yeah. Anyways, I'm going to sign off for now. If you've enjoyed this, please remember to like the stream. The YouTube's likes the engagement. If you haven't subscribed already, please subscribe. We just crossed 46,000 subscribers. Yes, excellent news. Very good. All the things. This is all very good. And, you know, remember to join all the stuff, and we'll say goodbye for now. Until later, my friends, I hope all's well. Cheers and goodbye.